I'm going to talk a little bit about the benefits and the concerns, barriers to development, give you a sense of the current liability structure. I'm going to very briefly touch on some other jurisdictions just to give you an idea of where we stand in the overall field, and then talk about what we can do in terms of removing some of these barriers. Development, which is often much maligned in the context of increased sprawl and the consumption of greenfields, is probably at its most green when it occurs in the context of a brownfield development. You're using non-greenfield lands, you're not contributing at all to sprawl, you're often using existing urban infrastructure. Even if it needs to be upgraded, a lot of the basics, a lot of the really expensive stuff is often already in place. You're in already a good location, or what used to be a good location, and you're contributing to urban regeneration. And a key aspect is that often brownfield remediation is the main driver of remediation. Without the brownfield redevelopment, the remediation won't happen. So you're doing a lot of good things from that point of view when you're seeing a development of brownfield. But of course, that's not all the good news. Then there's all the questions and all the concerns that tell you don't do it. Dickens wrote a great book in which he created a whole ministry called the Ministry of How Not to Do It. And if you remember it. And there's a lot of very easy questions or statements that could be made as to why not to develop a brownfield. The stakeholders and all the policy issues that drive liability are caused by concerns about this list of people in particular. The future occupants of your development, concerns about ecological receptors. Keep in mind the issue of water and the sensitive sites within the brownfields regulations. And keep in mind also that when we're talking about brownfields, these former industrial sites were typically at the main transportation, sources of transportation and power. And what were these? Water. So these are often properties that are right next to or very close to water. This creates problems now. It's a great opportunity because water is always a great location, but also tends to be a problem in terms of ecological receptors. Neighbors of your site are going to be concerned. They're going to be concerned just by the actual process of remediation, especially if there is active digging and moving of material. And they're going to be concerned about what happens later with the stuff that you will inevitably leave behind. Then, of course, ownership. All the liability issues are going to be concerns for your current owner, for the developer, and for future owners as well. Who are you going to sell to? And what are they going to know about the site? And what are they going to worry about their liability? Uncertainty, which I've put under the heading of ownership here, uncertainty just permeates the whole field, of course. And we've heard some comments about that earlier today. When you talk about environmental liability and you talk about brownfield liability, I think it's crucial to understand the unique nature of environmental liability compared to other forms of legal liability. It is unique when you have to deal with pollution underground simply because the pollution tends to be invisible. It's not like your regular car accident and other types of torts and legal problems that the law has dealt with for hundreds of years. The extent of the contamination is hard to see, it's hard to measure. The effects are potentially very long-term. You're not simply dealing with the one incident that happened right away. You're dealing with effects that could last over a lifetime if you're concerned about human receptors. The law simply hasn't had tools to deal with those in that simple a way. The scientific basis for what is safe is met with some skepticism and has, as we all know, changed over time. What defines safe? So if it's changed in the past 20 years, how do you know it's not going to change in the next 20 years? So the same levels that are safe today may well be unsafe tomorrow. The same contaminant may move over time. So where one neighbor maybe has a concern today, another neighbor next to that neighbor may have a concern tomorrow. So the receptors, the potential people who are going to be affected, who might one day have a liability claim, are going to change over time. And many of these issues are truly unique to environmental problems, and what makes them even more unique is that they're all present in the context of an environmental issue. You're dealing with questions of personal injury and property injury. You're dealing with short and long-term effects. You know, there may be permanent contamination of the land. It might not affect its use. A lot of liability questions are framed in terms of use. If it interferes with your use of your property, then you have a legal claim. But how much use do you make of that piece of land that's 30 foot below your house? Well, probably none, yet would you not expect some kind of recompense if there is contamination at that level below the place where you live every day? But the law says, well, but what for? And there's a concept of stigma and a concept of resale, but even that concept is in turn ultimately based on perception. Stigma is ultimately no more than a buyer will prefer to buy a clean property versus a contaminated one because they perceive there to be liability issues down the road. But are they real in the end? These aren't questions that the law usually has to ask when it comes to liability.